If you've been refreshing your USCIS case status week after week, month after month, desperately waiting for any sign of movement on your family immigration petition, what I'm about to share with you could change everything. Right now, as we speak in November 2025, something significant is happening behind the scenes at United States Citizenship and Immigration Services. The agency that holds the fate of thousands of separated families in its hands is finally showing signs of meaningful progress. And if you filed an I-130 petition this year, or you're still waiting from previous years, you need to hear this. Stay with me because the numbers I'm about to show you represent more than just statistics. They represent hope, reunion, and the possibility that your long wait might finally be coming to an end. Welcome back to USA Immigration Now, your trusted source for verified, accurate immigration updates straight from official government sources. I'm here to cut through the confusion, eliminate the speculation, and give you the facts you need to understand exactly where your family immigration case stands. If you're new here, go ahead and hit that subscribe button right now and make sure you turn on the notification bell so you never miss a critical update that could affect your immigration journey. Every video on this channel is thoroughly researched using only official USCIS data, State Department bulletins, and verified legal sources. Because when it comes to your family's future, accuracy matters more than anything else. Today, we're diving deep into the latest developments in I-130 processing times, the essential first step that allows United States citizens and lawful permanent residents to petition for their close family members. We're going to break down exactly what's changing, which categories are benefiting the most, what the current wait times look like across different service centers, and most importantly, what you can expect in the coming months as we head into 2026. I've spent hours analyzing the most recent data, consulting official USCIS processing time tools, reviewing National Visa Center timeframes, and examining the November Visa Bulletin to bring you the most comprehensive update available anywhere on the internet. So whether you're sponsoring your spouse, your parents, your children, or other family members, whether you filed your petition last month or you've been waiting for years, this video contains information that directly impacts your case. Let's get into it. Understanding the I-130 petition process. Before we dive into the numbers and the updates, let's make sure everyone understands exactly what we're talking about. Form I-130, officially called the Petition for Alien Relative, is the foundational document in family-based immigration. This is the form that United States citizens and green card holders file with USCIS to establish that they have a qualifying family relationship with someone who wants to immigrate to the United States. Think of it as the starting line in a very long race toward family reunification. When you file an I-130, you're not applying for a green card directly. Instead, you're asking USCIS to officially recognize and approve your family relationship. You're proving that you, as the petitioner, are either a U.S. citizen or a lawful permanent resident with the legal standing to sponsor someone, and you're documenting that the person you want to bring to America, called the beneficiary, is genuinely your spouse, parent, child, or sibling. This petition establishes what's called your priority date, which is essentially your place in line for an available visa number. The I-130 approval is absolutely critical because nothing else can move forward without it. No visa interview can be scheduled. No green card can be issued. No adjustment of status can be completed until USCIS approves this foundational petition. That's why processing times matter so much. Every month of delay means another month that families remain separated, another month that plans remain on hold, another month of uncertainty and stress. Current processing times, the numbers that matter. Now, let's talk about what's actually happening with processing times right now in November 2025. According to the latest data from USCIS and independent tracking services that monitor case progression in real time, immediate relative petitions for United States citizens are currently being processed in approximately 13 to 15 months on average. Let me repeat that because it's important. 13 to 15 months for immediate relatives of U.S. citizens. Now, I know what some of you are thinking. 13 to 15 months still sounds like a long time, and you're absolutely right. But here's the context that makes this significant. Just 1 year ago, in late 2024, these same petitions were taking 18 months or longer. We're talking about a reduction of 3 to 5 months in average processing time. That might not sound revolutionary, but for families who have been separated for years, for couples who can't start their lives together, for parents who are missing their children's milestones, those 3 to 5 months represent everything. The improvement is even more noticeable when we look at specific processing stages. Receipt notices, which used to take a month or longer to arrive after filing, are now appearing in USCIS online accounts within approximately 2 weeks. This might seem like a minor administrative detail, but that receipt notice means your case is officially in the system. It means you have a receipt number to track your case. It means you can stop wondering whether your petition was received and start focusing on the next steps. Different categories are experiencing different wait times. And this is crucial to understand. If you're a United States citizen petitioning for your spouse, unmarried child under 21, or parent, you fall into what's called the immediate relative category. These cases don't have annual visa caps, which means once your I-130 is approved, your relative can generally proceed to the next step without additional waiting for a visa number to become available. Current data shows these cases moving through in that 13 to 15-month time frame we mentioned. However, if you're a green card holder, also known as a lawful permanent resident, the situation is different. Green card holders can petition for spouses and unmarried children, but these cases fall under the F2A preference category, which does have annual visa limits. According to recent data, these petitions can take anywhere from 55 to 89 months, though this varies significantly based on the beneficiary's country of origin and current visa bulletin movement. Yes, you heard that correctly. We're talking about 4.5 to 7 years or more in some cases. For extended family categories, the wait times become even more substantial. If you're petitioning for married children, that's the F3 category, or siblings, that's the F4 category. You're looking at wait times that can stretch beyond 10 years, sometimes reaching 15 to 20 years, depending on your country of chargeability. These categories have been consistently backlogged for decades. And despite repeated calls for congressional reform to increase visa numbers, no major legislation has yet been passed to address these extraordinarily long waits. What's driving the improvement? So why are we seeing these improvements in processing times, particularly for immediate relatives? Several factors are contributing to the positive trend we're witnessing. First, USCIS has implemented strategic workforce reallocation. Officers who are working in less burdened departments have been temporarily reassigned to help process family-based petitions. This isn't a permanent staffing increase, but it's a smart use of existing resources to address backlogs that build up during the pandemic and through various policy transitions in recent years. Second, the agency has been under pressure from the current administration to increase efficiency and productivity. There's a renewed focus on processing legitimate petitions faster while maintaining rigorous security vetting standards. It's a delicate balance that immigration officers walk every day, move cases quickly without cutting corners on background checks and fraud detection. The emphasis right now is on what officials are calling speed with caution. Third, specific service centers that were previously notorious for lengthy delays are now showing marked improvement. The PTIC Service Center and Nebraska Service Center in particular have reported faster approval trends in recent months. While not all field offices are keeping the same pace, and there's still variation depending on where your case is being processed, there's visible progress happening across multiple centers. This is encouraging because it suggests the improvements aren't isolated to one location, but reflect broader systemic enhancements. Fourth, technology upgrades and digitization efforts are starting to pay dividends. USCIS has been slowly but steadily modernizing its systems, expanding electronic filing options, and improving digital communication between service centers and the National Visa Center. These improvements help reduce paperwork bottlenecks and make it easier for applicants to track their cases in real time. While there's still a long way to go before the entire system is fully digital, the progress being made is tangible. The National Visa Center stage. Now, USCIS approval of your I-130 petition is only half the story for most applicants. If your relative lives outside the United States, your case will move to the National Visa Center, or NFC, after USCIS approval. The MC is part of the State Department, and it plays a crucial role in preparing your case for the final step, the visa interview at a U.S. embassy or consulate abroad. The MC is responsible for several important tasks. They create your case file and assign you an MC case number. They collect additional fees, including the immigrant visa application fee and the affidavit of support fee. They review your DS-260 immigrant visa application form. They examine your civil documents, financial documents, and supporting evidence to ensure everything is complete and properly formatted. And finally, they coordinate with U.S. embassies and consulates to schedule your visa interview. Current MC processing times in November 2025 show that case creation, the initial step where MC receives your approved petition from USCIS and sets up your file, is taking approximately 2 to 8 weeks. Once your case is created, you'll receive a welcome letter with your MC case number and invoice ID number, which you'll need to access your online account on the Consular Electronic Application Center website known as CAC. After you submit all required documents and fees, the MC review process typically takes 2 to 4 months. During this review, MC officers examine every document for accuracy and completeness. If something is missing, incorrect, or unclear, they'll send you a checklist or reject the document, and you'll need to resubmit, which can add weeks or months to your timeline. Common issues that cause delays include incorrect document formats, missing signatures, inconsistent information between forms, and insufficient financial documentation on the affidavit of support. Once MC determines that your case is documentarily complete, sometimes called documentarily qualified, you enter the interview scheduling queue. Several factors are contributing to the positive trend we're witnessing. First, USCIS has implemented strategic workforce reallocation. Officers who are working in less burdened departments have been temporarily reassigned to help process family-based petitions. This isn't a permanent staffing increase, but it's a smart use of existing resources to address backlogs that build up during the pandemic and through various policy transitions in recent years. Second, the agency has been under pressure from the current administration to increase efficiency and productivity. There's a renewed focus on processing legitimate petitions faster while maintaining rigorous security vetting standards. It's a delicate balance that immigration officers walk every day, move cases quickly without cutting corners on background checks and fraud detection. The emphasis right now is on what officials are calling speed with caution. This is where things can get complicated because interview wait times vary dramatically depending on which U.S. embassy or consulate will process your case. Some consulates, particularly those in London, Abu Dhabi, and Warsaw, are currently scheduling interviews within 2 to 3 months of cases becoming documentarily complete. Other consulates, especially those in high-volume locations like Manila, Ciudad Juarez, Mumbai, and Lagos, can have wait times exceeding 12 months or even longer. The State Department has been working to expand interview capacity at many consulates, adding extra appointment slots to meet growing demand. This expansion is particularly important as we approach the new fiscal year. Officials hope these increases in capacity will help clear backlogs by early 2026. For families waiting for interviews in high-volume consulates, this expansion could mean the difference between waiting another year or getting scheduled within a few months. The visa bulletin and priority dates. For those of you in preference categories, particularly F2A for spouses and children of green card holders, you need to understand how the visa bulletin works. Every month, the State Department publishes what's called the Visa Bulletin, which tells you when visa numbers are currently available for different categories and countries. Your priority date, which is the date USCIS received your I-130 petition, must be current according to the Visa Bulletin before you can move forward with your visa interview or adjustment of status. Throughout 2024 and early 2025, the F2A category faced near stagnation. The Visa Bulletin dates were barely moving, sometimes advancing by just a few weeks per month, sometimes not moving at all, and occasionally even retrogressing backward. This was incredibly frustrating for families who had been waiting for years and suddenly saw their wait times extend even further. But in recent months, we're seeing more consistent forward movement. The bulletin is now advancing by approximately 1 to 2 months per update. It's not dramatic progress, but after a year of minimal movement, it represents genuine hope for thousands of waiting families. The coordination between USCIS and the State Department has strengthened this quarter, and both agencies are working together to better align the allocation of family-based visa numbers. The goal is to prevent what's called retrogression. Those situations where visa bulletin dates suddenly jump backward, causing applicants who thought they were close to their interviews to suddenly find themselves years away again. If this improved coordination holds through early 2026, we should see more stable and predictable visa bulletin movement, which would be enormously beneficial for planning purposes. What you need to do right now, whether you've already filed your I-130 petition or you're preparing to file, there are specific actions you should take to maximize your chances of a smooth, efficient process. First, and most importantly, accuracy and completeness are everything. USCIS has made it clear that they're scrutinizing applications more carefully than ever. A missing document, a mismatched date, an unclear explanation, or insufficient proof of your family relationship can trigger what's called a request for evidence, or RF. When you receive an RF, your case is essentially put on hold until you respond with the additional information or corrections they're requesting. This can add 3 to 6 months or more to your processing time. Before you submit anything to USCIS or NVC, triple-check every single detail. Make sure your names are spelled consistently across all documents. Verify that dates of birth, marriage dates, and other key information match exactly on every form and supporting document. If you're filing as a married couple, ensure your marriage certificate is official, properly translated. If necessary and clearly legible. If you're petitioning for a parent or child, make sure birth certificates show the required information and are properly authenticated. The goal is to create a petition that is so well organized and complete that an immigration officer can approve it without needing to ask you for anything additional. Second, keep your contact information current with USCIS. If you move, if you change your email address, if you get a new phone number, you need to notify USCIS immediately using Form AR-11 for change of address. Many applicants miss critical notices because USCIS sent them to an old address. Missing a request for evidence, missing an interview notice, or missing any communication from USCIS can result in your case being denied or administratively closed. Third, regularly monitor your case status. USCIS provides an online case status tool where you can enter your receipt number and see real-time updates on your case. Check it at least once a week. Sign up for text and email notifications so you're immediately alerted when there's any change in your case status. For those of you whose cases have moved to NC, log into your CAC account regularly to check for messages and status updates. The NC communicates primarily through the CAC portal, and you're expected to respond promptly when they request additional information or documents. Fourth, prepare your supporting documents in advance. Even if NVC hasn't requested them yet, start gathering your civil documents now. Get your birth certificates, marriage certificates, divorce decrees, police certificates, and any other required documents. If you need to obtain documents from another country, start that process immediately because international document requests can take months. Make sure everything is properly translated by a certified translator if it's not in English. The more prepared you are when NC does request documents, the faster you can submit everything and move toward being documentarily complete. Fifth, understand your financial obligations. The person sponsoring a family member must submit an affidavit of support, Form I-864, proving they have sufficient income or assets to support their relative at 125% of the federal poverty guidelines. If you don't meet the income requirements on your own, you may need a joint sponsor. Start planning this financial aspect early because insufficient financial documentation is one of the most common reasons for delays and denials in family immigration cases. What's coming in early 2026? As we look ahead to the first quarter of 2026, there are reasons for cautious optimism. USCIS insiders suggest that additional efficiency measures may be announced in the coming months. These could include expanded electronic filing options, which would reduce paper processing delays and make the system more accessible. There's also talk of improved digital communication systems between USCIS service centers and the National Visa Center, which would reduce the time it takes for approved petitions to transfer and for cases to move through each stage of the process. The State Department continues to work on expanding consular interview capacity worldwide. While some embassies and consulates face staffing challenges and security concerns that limit how quickly they can add appointments, the overall trend is toward increased availability. If you filed your I-130 petition between late 2024 and mid-2025 and you're in the immediate relative category, you may begin seeing faster communication and case movement through the first quarter of 2026. However, it's important to maintain realistic expectations. Extended family preference categories, such as F3 for married adult children and F4 for siblings of U.S. citizens, remain heavily backlogged with wait times exceeding 10 years for many countries. Unfortunately, despite repeated calls for reform, no major legislative breakthrough has yet occurred in Congress to address these extraordinarily long queues. Bills like the proposed reforms to increase visa numbers for family preference categories remain under discussion, but they have not been enacted into law. Until Congress acts to fundamentally restructure the system or significantly increase visa numbers, these categories will continue to face decadal-long waits. The human side of immigration processing. Behind every I-130 petition, behind every case number, behind every processing time statistic, there's a real human story. There's a husband who hasn't seen his wife in person for 2 years, communicating only through video calls across time zones. There's a mother who's missing her daughter's childhood, watching her grow up through photographs sent by relatives. There's a father who's working multiple jobs in the United States, sending money home, desperate to bring his family to join him. There's an elderly parent who's counting down the days until they can finally meet their grandchildren in person. These aren't abstract policy debates. These are real people whose lives are on hold, whose dreams are deferred, whose families are separated by bureaucracy and backlogs. When we talk about processing times dropping from 18 months to 15 months, we're not just talking about administrative efficiency. We're talking about 3 fewer months that a family has to remain apart. We're talking about 3 months of someone's childhood that a parent doesn't miss. We're talking about 3 months closer to the day when a couple can finally start their life together in the same country. This is why accuracy matters so much in your application. This is why staying informed matters. This is why understanding the system matters, because every mistake, every delay, every missed notification extends the separation. And while the U.S. immigration system is complex, often frustrating, and frequently slow, it does continue to move forward. Every day, petitions are approved. Every day, visa interviews are conducted. Every day, families are reunited. Your case will eventually reach its conclusion. The question is whether you've positioned yourself to move through the system as efficiently as possible. Regional variations and service center differences. It's important to understand that not all USCIS service centers are processing cases at the same speed. Where your petition is processed can significantly affect your timeline. As of November 2025, different service centers are showing different performance levels. Some centers are consistently processing cases well within the 13 to 15-month average we've been discussing, while others are still struggling with backlogs that can extend wait times to 18 months or longer. The challenge is that you generally cannot choose which service center processes your petition. USCIS assigns cases based on factors like where you live, where your relative lives, and current workload distribution across centers. However, knowing which service center is handling your case can help you set more accurate expectations. You can find this information on your receipt notice under the service center location or by looking at the first 3 letters of your receipt number. Some service centers have historically been faster than others. For example, certain centers that specialize in employment-based cases may process family petitions more quickly because they have less volume in those categories. Other centers that handle high volumes of family petitions may face longer backlogs simply due to the sheer number of cases they're managing. USCIS does try to balance workloads by transferring cases between centers when necessary, but this can sometimes add to processing times as your case moves from one location to another. Common mistakes that cause delays. After years of covering immigration cases and analyzing processing data, certain mistakes come up again and again. These are the errors that cause unnecessary delays, trigger requests for evidence, and sometimes lead to denials that could have been avoided. Learn from others' mistakes so you don't make them yourself. One of the most common errors is submitting incomplete or inconsistent biographical information. Your name must be spelled exactly the same way on every single form and document. If your birth certificate says John Michael Smith, but your passport says John M. Smith, you need to provide an explanation. If there are any discrepancies in dates of birth, places of birth, or names, address them up front with a detailed letter of explanation and supporting documentation. Another frequent mistake is insufficient evidence of the family relationship. For marriage-based petitions, USCIS wants to see proof that your marriage is genuine and not entered into solely for immigration purposes. This means you should submit evidence of your life together. Joint bank account statements, joint lease or mortgage documents, utility bills in both names, insurance policies listing each other as beneficiaries, photographs together from throughout your relationship, and affidavit from friends and family who can attest to your marriage. Don't just submit the bare minimum. Build a comprehensive picture of your genuine marital relationship. For parent-child petitions, the birth certificate is crucial, but sometimes it's not enough. If the parent's name on the birth certificate doesn't match their current legal name, you'll need to provide documentation of any name changes, such as marriage certificates or court orders. If you're petitioning for an adopted child, you'll need to provide extensive adoption documentation and proof that the adoption meets specific requirements under U.S. immigration law. Financial documentation on Form I-864, the Affidavit of Support, is another area where many petitions hit problems. The sponsor must prove they have sufficient income or assets to support the intending immigrant at 125% of the federal poverty guidelines for their household size. This means providing complete tax returns for the most recent 3 years, current pay-ups, an employment verification letter, and sometimes additional evidence like bank statements or property valuations. If your income alone doesn't meet the requirements, you'll need a qualified joint sponsor who can submit their own complete I-864 package. The importance of proper documentation. Immigration cases are won or lost on documentation. USCIS adjudicators can only base their decisions on the evidence you provide. They cannot assume facts, not in evidence. They cannot fill in gaps with their own knowledge or research. Everything must be documented, proven, and submitted in the proper format. For civil documents like birth certificates and marriage certificates, USCIS requires original documents or certified copies issued by the official custodian of records in the country where the event occurred. A photocopy of a birth certificate is not acceptable. A certificate issued by a hospital is not acceptable if that country's vital records are maintained by a government office. If the original document cannot be obtained, you must submit a letter from the appropriate government office stating that the document is not available along with secondary evidence such as church records, school records, or affidavit from people with personal knowledge of the facts. Translation is another critical issue. Every document not in English must be accompanied by a certified translation. The translator must be competent in both English and the foreign language, and they must provide a signed statement certifying that they are competent to translate and that the translation is complete and accurate. The translator cannot be a party to the petition, which means you cannot translate your own documents, and your spouse cannot translate documents for your petition.